You might have heard me use these terms reason to believe and being satisfied a lot in the videos on this channel, and I thought it'd actually be really useful to explore them in more depth because they're two thresholds within the homeless application process which so much depends on. So I'm going to go into a few bits of detail. The reason I'm having to do that is that loads of housing officers simply don't understand how low these thresholds are, and actually lots of professionals in the sector mix up the two thresholds altogether. They actually confuse the wording. And in order to illustrate this as best I can, I'm going to tell you a story which actually happened. This is a real story, as unbelievable as it might seem, which happened in Bedford Borough back maybe 5 years ago. And my old colleague John Allen, who runs Just Us in Bedford, was essentially supporting someone who's fleeing domestic abuse to go to the council to get help. And just to explain the timing of this was before the Domestic Abuse Act came in 2021, so it's like 2019 time, maybe about a year before COVID. And so this lady was not automatically in priority need because of the fact she was fleeing domestic abuse. However, she was heavily pregnant, so she was something like 30 weeks pregnant. I'm not exactly sure how pregnant she was. And John had emailed ahead because he's sensible. He realises it's a legal process, just to inform the council that he's going to be coming down to the council with her in order to get a temporary accommodation that night. Now, he gets to the council. It's like many councils, open plan customer service centre. In Bedford, it's actually in the old Civic Theatre. It's been converted, and you basically got 10 desks. They're like this far apart from each other, and you're basically supposed to go and speak to a housing officer and share all your kind of most sensitive information in broad daylight and kind of clear earshot of loads of other people. That's something we complained about in Bedford and made sure that wasn't happening. So in this case, he knew he was going to get a private interview room. And when he saw the housing officer who was going to be conducting the interview, he kind of just died a little bit inside, because in that period, in 2019 in Bedford, we'd had a whole spate of really bad housing officers, lots of temps who really got up to some very disgusting things. It actually took some months to get oiked out, during which time we saw the most outrageous failures in any council we've ever seen because of the actions of these kind of small handful of housing officers. So John realised who was going to be doing the interview. He warned the client. He said, look, this is going to be rough. Let's just get a roof over your head tonight. We'll worry about complaining or kind of dealing with other stuff as we go on later on. And sure enough, they get into this little private interview room. It's kind of cramped, you kind of all sort of squeezed into this room, like there's not really enough room for the chairs. You're across the desk from this housing officer, and she basically launched straight away into being pretty unpleasant and being pretty bullish in terms of how she was asking questions, and kind of almost kind of put out that this lady had actually gone to the council for assistance, which isn't unusual. I've kind of come across that attitude quite a lot within housing option staff. And basically John explained the situation, explained why they were there, basically giving the council very clear reason to believe that she might be homeless, might be eligible, might be in priority needs, and therefore triggering that duty to accommodate under section 108, so in order to provide interim accommodation. And essentially the housing officer kind of looked up from her desk, looked at this lady and kind of looked her up and down and said, nah, here's a pregnancy test. I want you to go to the customer service toilets and prove to me that you're pregnant. And John basically kind of said, you know what, let's just get this done. Let's get a roof over your head. We'll complain about all this later. And so sure enough, the client went to the customer service toilets, did the pregnancy test, came back, it's positive. And the housing officer takes the pregnancy test, looks at it and says, nah, I'm going to need to see your green book, guys. And again, John's just like, look, let's just get you out of here. Let's get a roof over your head. We'll worry about complaining later. So they're able to produce the green book. And again, the housing officer looked at it at Green Book and sort of rifled through the pages. There's clear details that she was pregnant, obviously, but kind of shook her head and said, nah, this isn't enough. I'm going to need to see a scan photo. So sure enough, the lady was able to go and get a scan photo, produce it, and that was enough to get the interim accommodation that night. And John then complained about it, and the temporary housing officer didn't last much longer after that, although way too long in my opinion. But this is kind of raises this massive issue that there is when you're making homeless applications in terms of the level of evidence you're supposed to be providing to actually get temporary accommodation or whatever. So this is something which is kind of laid out very clearly within the Code of Guidance and also case law. And it's really important to understand that the homeless application process is part of a legal process. That means you do see cases end up in the Supreme Court, about priority need or intentional homelessness or about affordability or whatever. It's not unusual at all. And so in one sense, when you get to that stage of having to go to court, so it's quite a long way down the process, when you actually get to the appeal process, when you actually have to go to court, you do have to basically make your case. You have to kind of say why it is you think you're in priority need or why you think you're not intentionally homeless or whatever. So there is a kind of burden on proof on you at that point to produce some kind of argument to say yes, you're in priority need or whatever. But earlier on in the process, you do not have to prove your case. So the way the housing law is designed is essentially there's meant to be no wrong door. That means if you are vulnerable, if you're fleeing domestic abuse or whatever, and you kind of happen to sort of wander into a council or wander into some sort of statutory service, they should immediately pick you up and basically make sure that you're treated lawfully and that you're safely housed. So again, the Code of Guidance is very clear. You can make homeless applications to any department of the housing authority. So if once it's that interaction, you ask the council for help with housing and you give them reason to believe that you might be homeless or you might be threatened with homelessness, then the application has already been triggered. That's very clearly laid out within the law. 18.5 of the Code of Guidance, I think, if you want to check it out, just to check I'm not making it up as I go along. So that is kind of clearly how it's supposed to work. And if you think about it, it's a really good set of law for that reason. The idea is that no one is left out homeless if there is, you know, kind of any reason to believe that they might be in priority need, as in they might be vulnerable or they might have one of those automatic characteristics. But as we see in practice, and I'm sure if you're watching these videos, you're going to be very familiar with the kind of things councils do. They essentially apply that kind of that you know, beyond all reasonable doubt threshold, even at the very cursory first stages, and it's completely unlawful. But because no one challenges it effectively, it just keeps going, and housing officers say, oh well, there's nothing we can do, you know, there's not enough housing or whatever, and they don't recognise that they have agency. And if they're being told to break the law by their bosses, or they're being put in a position where they can't possibly follow the law, it's on them to raise grievances, to whistleblow or do whatever. But instead they kind of swallow it. They try and make the best they can of the situation, and gatekeeping continues to be prevalent in the country, and hundreds of thousands of people are left homeless because of it. So let's actually kind of unpick these two thresholds. As I say, there's this kind of reason to believe, this initial threshold, which I'll talk more about in a second, and then there's this threshold of being satisfied. And just to kind of give you an example of how this would work. So in the case of John's client, when she approached the council and she gave them reason to believe that she might be homeless, might be eligible for assistance, and might have a priority need, the interim duty to accommodate kicked in. And then the homeless application continues. So she's in safe B&B or safe emergency accommodation or whatever. The council's next job is to essentially carry out inquiries. And their first question is, are they satisfied this person is eligible? As in, you know, on the balance of probabilities, is this person eligible for assistance? And on the balance of probabilities, are they satisfied that this person is homeless? And if the answer is yes to both of those questions, the relief duty kicks in. So you can see there's this kind of two thresholds which kind of kick in fairly early on in the process. You know, it could technically be within the first couple of minutes of actually approaching a council potentially. And how they're interpreted by the housing officer is going to make a massive difference, because, as I say, in the case of, you know, of a housing officer who's literally denying that someone's pregnant until they produce 3 different kinds of evidence, that is clearly a misapplication of the law. So, as I say, and I'll give that example, it sounds crazy, but that's actually a fairly kind of common occurrence in different ways. So if we actually explore these kind of the wording here, so reason to believe that you might be homeless, that's enough to trigger the homeless application. And as I say, it's not about kind of being satisfied that you are homeless in those initial stages. There's actually a couple of really good LGO cases which illustrate this really well. So for example, there's an LGO case which I'll put the code up on the screen if you want to Google it yourself, and it basically made the point, in fact I'll read it. So at that stage, as in the initial homeless application stage, as in presenting to the council, the evidence does not have to confirm the person is homeless or threatened with homelessness. The council only has to have reason to believe this might be the case. So as I say, unless the council has really kind of, you know, got hard evidence that you're not homeless, they have to accept that you might be homeless, and therefore they need to carry out these inquiries. And if you look on the YouTube channel, I did a video back in 2020, had 3 judges on the panel, including Jan Luber, who's basically writes the industry standard textbook for the sector, and he makes exactly this point. So if you just search on the channel for section, so S.184, you'll find that video, and as I say, you hear it from 3 incredibly experienced judges talking about this issue, again, if you don't want to take my word for it. So that's a really good example. So it's kind of saying you don't have to prove anything at that initial instance, you just need to give the council reason to believe that you might be homeless, or in the case of section 1.8, you might be homeless, might be eligible, might be in priority need. If you actually look at case law, there's another case called Gravesham XP Winchester, which again I'll put into the video description if you want to search more about it. And it basically says that councils don't have to carry out detailed CID type inquiries. And the reason they're kind of saying that in that situation is, I can't remember what CID stands for, but it's something to do with detectives and kind of police investigations and criminal kind of investigations, criminal cases. And as I say, you'll be familiar with this term beyond all reasonable doubt because you'll see it in all the TV dramas and whatever. And that only applies to criminal law. So in a criminal case, the prosecution has to prove beyond all reasonable doubt that the person is guilty of the crime if they're going to actually send them to prison. But in housing law, in homelessness law, it all comes under civil law. And in civil law, the threshold, even when you get to court, is on the balance of probabilities. So that idea of being satisfied is something akin to, being satisfied that on the balance of probabilities, this person is homeless or this person is eligible for assistance, which, as I say, is when the relief duty kicks in. But this lower threshold of reason to believe that you might be is clearly much lower than that. And again, the guidance kind of makes this point. So there's another LGO case, which again I'll flash up on the screen. Basically, again, there's a pregnant lady. She's approaching a London council. The LGO decision notice basically made this point really well. So it said, Miss Q, as anonymised, telling the council she was pregnant was enough to trigger the duty to provide interim accommodation in these circumstances, as in she'd made the application. It should have provided the interim accommodation and then asked her for evidence. That's the way it should work. And in one sense, if you look at that Gravesham case where it says it's not for the applicant to prove their case, in a case where you're going to a council and you're saying you're pregnant, you might have your green book with you, great. But if you haven't, might be you've just fled abuse, you might be you don't have that information available. It's not for you to provide it. It's for the council to make those inquiries. And that would often mean them writing to your midwife or writing to your GP to get the evidence they need to be satisfied that you are in fact in priority need. So that and those initial duties at those two stages, so making a homeless application under section 184 and triggering that interim duty to accommodate under section 108, that is both the reason to believe that you might be homeless or reason to believe that you might be homeless, might be eligible, might be in priority need. Whereas once you get into the relief duty, the council needs to be satisfied that you are homeless and satisfied that you are eligible. And then if you get through the relief period and you get to that final decision, the section 184 decision about whether the main housing duty is owed or not, the council has to be satisfied that you are homeless, you are eligible, you are in priority needs, you're not intentionally homeless, and local connection hasn't kicked in or whatever. So local connection's a bit of an odd one with that. And actually there's another kind of threshold which potentially you might be able to bring in here in terms of intentional homelessness, because in the case of intentional homelessness, it's on the council to really prove that you are intentionally homeless. So it says the benefit of the doubt, or the benefit of any doubt, I think if I remember the wording right, has to go to the applicant if the council can't prove that they are intentionally homeless. So again, you kind of see a slightly different threshold there. But when you're kind of presenting information about priority needs, so pregnancy, dependent children, all that sort of stuff, the council don't need to kind of carry out these detailed CID type inquiries. They're not having to prove beyond all reasonable doubt that you are owed that main housing duty. It is just balance of probabilities. And again, one of the kind of mistakes that a lot of people I see make is that they mix these two definitions up. So they'll say reason to believe that you are homeless to trigger a homeless application. Now, if you think about it, the operative part of that term, reason to believe that you might be homeless, is not the reason to believe. It's actually the key word here is might, is possible, maybe. That's the key word. And so they kind of mix these two thresholds up, and it kind of leads to all sorts of problems. So if you're making that initial application, you only have to cross a low threshold when you're starting off. So if you say to council, I'm homeless, can you help me out? You've triggered a homeless application, whether they like it or not. And then if you give them reasons to believe that you might be homeless, might be eligible, might be in priority need, then the duty to provide interim accommodation is immediate. That's the way it works. And then they have to carry out these inquiries, as that LGO case said very nicely. So hopefully that makes sense. The reality is that this is the kind of grind that you have to do if you're an advocate. You have to grind down the council and get them to use the threshold properly. And it takes time. It takes upheld complaints. It takes kind of raising issues politically, but it can be done. And actually, as an interesting kind of point, I might just kind of talk about the verification process of rough sleepers. So again, it's something that you might have heard of. It might be that you haven't rough slept, so it wouldn't apply to you. But if you're rough sleeping, and there's basically means you're on the streets. So there's a bit more to it than that. The way a lot of councils operate is, you go to a council and you say, I'm homeless, can you help me out? And they say, oh, you're rough sleeping. You need to go back to your spot, and the verification team, the rough sleeper outreach team, will come and find you and basically prove that you are in fact homeless before they'll help. And you can see how that is by definition unlawful, because by going to the council saying you're rough sleeping or saying any form of homelessness, you're giving them reason to believe that you might be homeless. They do not need to prove it, and the whole verification of rough sleepers process is essentially trying to validate this practice that councils have of applicants having to prove that they are homeless before they get help. So there is a bit more to say about verification. I've talked about it elsewhere. It's one of the reasons why I just think it stinks. You can't end rough sleeping by treating rough sleepers unlawfully. It just doesn't work. You need to treat them as citizens of the country, because they are, and you need to treat them according to their rights if you're actually going to get anywhere with them, because the minute you kind of disbelieve someone, you can't possibly regain that rapport, and it makes it very unpleasant for the whole process. And again and again and again, the feedback I hear from people who've been homeless is, and it's really weird, you know, you might be surprised by this, they say the worst thing about being homeless was how they were treated by that local authority, and the fact that they were disbelieved, the fact that they were having to prove things, the fact that that kind of default attitude from the housing officer was just unpleasant and kind of bullish and just putting people off. And I think housing officers, even the kind of nicer ones, don't really kind of acknowledge how much damage that does, and how much damage it does to our society when you're doing it to 100,000 people every year, give or take. You know, and that's not an exact figure, but you know what I mean. So yeah, that's something that I hope kind of clears a few things up. I'll put those key cases in the description just so you can keep up with it. But yeah, again, you know, you can quote the code of guidance, you can quote those cases if you're ever making a complaint. The more information you have when you make a complaint, the better, as in it's better to have written records of what was said and what wasn't said. But it can be done. In Bedford Borough, we have turned that council's practice around. You know, I know that sounds really kind of grandiose and everything, and in one sense, I will never know exactly what impact we had, but we had so many cases where we would complain about exactly this kind of thing, and it's kind of led to, in one sense, temporary accommodation being utterly overwhelmed, if nothing else, which isn't a good thing in itself, but it shows that the council is engaging with these duties properly. So I'm probably going to do a separate video about kind of just how dramatic an impact we've had in that way. But yeah, so yeah, as I say, it can be done. Holding council to account, putting the code of guidance to them, is a real good way to actually get those practices to change. And if you think about it, that kind of baseline principle of the Housing Act is, the Housing Act should, if the Housing Act was followed, no one who was actually vulnerable would ever get left out rough sleeping or whatever, or left homeless, because if there was reason to believe that they might possibly be in priority need or whatever, then they would be whisked off into safe temporary accommodation, and then the inquiry process would happen. But what we see so many times, time and again, is where people who are told, oh, there's no reason to think you might be in priority need, sent back to the streets, and then an advocate gets involved, like Just Us, and basically just takes the council to task and actually shows that not only is there reason to believe that they might be in priority need, but actually clearly that they are in fact in priority need, and actually get that main housing duty down the line. So if you don't challenge councils, they'll just keep getting away with it. It's really important, but it can be done. It's worth the effort. Basically, you get a lot of people housed that way, and ultimately you push up standards in the sector and you get things working a bit better. So yeah, hopefully that helps. As always, if you've got questions about this, put it into the comments. I'll answer it in the weekly live stream. It's usually Thursdays at 7:30 p.m. Myself, my colleague Shannon, and Will Flack, who's a really experienced solicitor, we basically try and answer as many questions as we can in the hour. And also, if you're working in a professional setting and you want to know more about this sort of stuff, do check out our training. It's basically every month or so there's an online course, very reasonably priced. We get amazing feedback. It's worth just checking out the feedback we've had on Trustpilot, because, you know, again, it's not fake. There's 70 reviews in there or something. So what a lot of people say is that it's the best training they've ever done.